Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Imagine you've poured, years into creating something unique, something that genuinely helps people, right? And then suddenly someone else starts selling, well, basically a copy, benefiting from all your hard work. What happens next? Today, we're taking a deep dive into a really fascinating recent court judgment that address just that scenario. It involves a very specific agrochemical formulation.
That's exactly right. Our mission today is to dissect a judgment from the Delhi High Court. We want to understand the critical nuances of patent infringement. We'll specifically look at how distributors can get pulled in, how they can be held liable, and also the powerful role of admitted facts in court. This case, it offers some pretty profound insights into what it really means to protect intellectual property, in India.
Okay, and for this deep dive, we're relying on just one source, but it's the key one. The judgment itself. GSPV, BAU, AGRO.PDF. Our goal is to pull out the most crucial insights for you, to help you grasp the core arguments, the court's reasoning, and, well, what it all means for anyone navigating patents and business. So let's kick things off by setting the stage. Who are the players here? And give us the quick overview of the court stuff.
Right. So this was actually a remarkably swift decision from the Delhi High Court. It was handed down by Justice Saurabh Banerjee. The judgment itself, it was reserved on July 11th, 2025, and then pronounced just 2 weeks later, July 25th. That speed, it kind of tells you something about how clear the facts likely were in this case. The plaintiff here is GSP Crop Science Ltd. The defendants are BR Agrotech Ltd. And another party. But for this specific judgment we're looking at, our focus is really on defendant number 2.
Got it. And who are the legal teams? Who is representing them?
Okay, so for the plaintiff, GSP, we had Mr. G. Nataraj and Mr. Rahul Bhujbal. And representing defendant number 2, it was Mr. Saurabh Bhargavan, Mr. Nikhil S. Nair, and Mrs. Chinju Saurabh.
Right. Now that we know who's who, let's get to the core of it, the invention, the patent that started this whole thing.
Okay. The plaintiff, GSP Crop Science, they're based in Ahmedabad. Big focus on R&D and agrochemicals. Apparently, they hold over 70 patents and applications. The key one here, though, is Indian patent number 394568. Let's just call it IN 568.
IN 568. What exactly does it protect? What's special about this formulation?
It's quite specific. It covers what's called a synergistic suspo-emulsion formulation. Basically, it combines 2 key agrochemical ingredients, one called Pyriproxyfen, between 1% and 15%, and another diafenthiuron, between 25% and 55%, plus, some inactive stuff. The patent covers both the mix itself and how to make it.
Synergistic. So the combination is better than the parts, what makes it innovative?
Exactly. Testing showed 2 main benefits. First, improved stability over time. That's pretty important for agrochemicals, shelf life, and all that. Second, and maybe more critical for the end user, the farmer, it showed better efficacy against certain pests, specifically whiteflies on cotton and tomato leaf miners. It worked better together than the ingredients did on their own.
Sounds like a real step forward then. But getting the patent, was that straightforward for GSP?
Oh, not at all. Far from it. The application went in way back in 2014, but the patent wasn't actually granted until 2022. 8 years. And during that time, it faced a whole bunch of challenges. 7 pre-grant oppositions, all rejected. Plus, there were even 2 writ petitions filed by another company, Best Agro Life Limited, that went all the way to the Delhi High Court. But in the end, IN 568's validity was upheld. It was even acknowledged by Best Agro Life in a settlement agreement. So, yeah, definitely a hard-won patent. No smooth sailing there.
Wow, okay. So after all that effort, they finally get the patent. What did GSP do with it then? Did they commercialize it?
They did. They launched an insecticide called SLR 525. It contained 5% pyriproxyfen and 25% diafenthiuron right within their patent claims. They've been selling this since 2018, and it had all the necessary regulatory approvals, too, under the Insecticides Act.
Okay, so GSP has this hard-won patent, a successful product on the market. When did the trouble start? When did they realize someone might be copying them?
Well, around 2022-23, GSP found out that defendant number 2 was selling a product called Roxyfin. And the thing that really jumped out was that Roxyfin claimed the exact same composition, 5% Pyriproxyfen, 25% Diafenthiuron, a suspo-emulsion. It turned out Roxyfin was actually manufactured by defendant number 1, and defendant number 1 did have a license for it under Section 9(4) of the Insecticides Act. But that type of license, it's often for what they call Me Too registrations. It lets companies sell similar formulations, but critically, it doesn't give you a free pass to infringe someone else's patent.
Right, that's a key distinction. So what did GSP do when they found this Roxyfin product? What was their legal move?
They acted fast. GSP filed a suit asking for a permanent injunction against both defendants, the manufacturer and the seller. They got an initial temporary halt, an ad interim injunction pretty quickly in February 2023. Then something interesting happened. In early March 2023, the suit was actually settled against defendant number 1, the manufacturer. Defendant number 1 acknowledged GSP's exclusive rights and, importantly, admitted they'd sold the infringing product to defendant number 2. After that settlement, the temporary injunction was made permanent or absolute, specifically against defendant number 2 in July 2024.
Okay, so defendant number 1 settles and admits selling to defendant number 2. That puts defendant number 2 squarely in the spotlight. So what were the specific legal questions the court needed to tackle for this application, just against defendant number 2?
The court basically boiled it down to 2 key questions. First, was defendant number 2, acting as a marketer or seller, actually infringing the patent under Section 48 of the Patents Act? Does selling count? And second, did defendant number 2 make admissions of fact that were clear enough to justify a judgment against them right away using Order 12, Rule 6 of the Civil Procedure Code? That's the rule for getting a judgment based on admissions without a full trial.
Right. Let's dig into the arguments then. What was the plaintiff GSP's main case? How did they argue defendant number 2 was infringing?
GSP's argument was pretty straightforward. They said, look, IN 568 is valid, no question. And Section 48 of the Patents Act gives us the exclusive right to stop others from making, using, offering for sale, selling, or importing our patented invention. They argued that defendant number 2 selling Roxyfin, which had the identical composition, was just, well, they called it textbook infringement.
And how did defendant number 1's settlement play into their argument against defendant number 2?
That was a big piece. GSP pointed out that defendant number 1's regulatory approval was just a Me Too thing, not a license to infringe. And the fact that defendant number 1 settled, admitted infringing, and specifically admitted selling the product to defendant number 2, well, that really strengthened GSP's case, that defendant number 2 knew or should have known what they were selling.
Okay, and you mentioned admissions being key for that second legal question about getting a quick judgment. What were these specific admissions by defendant number 2?
Yes, this was crucial for GSP's strategy using Order 12, Rule 6. They highlighted 3 things. First, defendant number 2 filed an affidavit dated May 2nd, 2023. In it, they explicitly stated they purchased Roxyfin from defendant number 1. And they didn't just say they bought it, they gave detailed sales figures. 17,632 liters sold in 2021-22 for over 2.2 crore rupees and 18,000 liters in 2022-23 for another 2.24 crore rupees. Huge amounts.
Wow, they admitted sales and the amounts. That seems quite direct. What were the other 2 admissions?
The second one was from another affidavit, April 13th, 2023. Defendant number 2 said something like, if any infringement was done by defendant number 1, that's between the plaintiff and defendant number 1, we're not concerned. GSP argued this was basically admitting the sales happened while trying to wash their hands of any responsibility, kind of a not my problem defense. And third, in their formal written statement to the court, defendant number 2 actually admitted they were acting as the marketing entity for defendant number 1's product.
So putting those together, admitting buying it, admitting the sales figures, admitting being the marketer, GSP, felt this was enough to say, game over, no need for a trial.
Precisely. They argued these admissions were plain, unambiguous, and unequivocal. They brought up case law, like Udham Singh Duggal and Delhi Jal Board, precedents that say Order 12, Rule 6 is there for exactly this kind of situation, speedy justice when the facts are admitted. Their point was, why drag this out? Defendant number 2 admitted the core facts, were entitled to a judgment now.
Makes sense from their perspective. It does sound like a strong position based on those admissions. But what was defendant number 2's response? How did they defend themselves against this?
Well, defendant number 2 tried a few angles. Their main argument was that they were just an honest marketing entity. They emphasized that defendant number 1, the manufacturer, held the actual CIBRC license for the product. They claimed there was no collusion or conspiracy to infringe the patent, so the suit shouldn't even be against them. They also argued that since defendant number 1 had already settled, and that settlements supposedly covered all the sales proceeds, including the sales made through defendant number 2, there was no remaining cause of action. Basically, GSP couldn't double dip and get more money from them.
Okay, so just the marketer defense and the already paid up defense. But what about those specific statements, the affidavits admitting sales? Did they try to retract those or explain them away?
They didn't deny making the statements, no. But they argued the statements didn't meet the high bar for Order 12, Rule 6. They claimed the admissions weren't clear, unambiguous, and unconditional. They tried to frame them as contextual, maybe conditional, only related to historical sales. They insisted they had no intention of future infringement. They also pointed to other parts of their written statement where they denied things or offered justifications, suggesting the court needed to look at the whole picture, not just the admissions in isolation.
Right, trying to muddy the waters a bit. Did they have any other major arguments?
Yes, one final point. They accused GSP of pursuing the case against them in bad faith. A malified attempt was the legal term. They claimed GSP was just trying to pressure them into withdrawing a separate challenge. Defendant number 2 had filed against the validity of GSP's patent, IN 568, those post-grant opposition proceedings.
Oh, interesting twist. So after hearing all these arguments, the plaintiff's case based on infringement and admissions, the defendant's counter-arguments about being just a marketer, and the admissions not being clear, what did the High Court decide? What was the final ruling?
The court came down clearly on the side of the plaintiff. It allowed GSP's application and decreed the suit in their favor against defendant number 2. This meant defendant number 2, its directors, employees, everyone acting for them, was permanently stopped, restrained from making, using, selling, distributing, advertising, exporting, basically doing anything with any product that infringes IN 568, specifically that Pyriproxyfen and Diafenthiuron formulation.
A permanent injunction. Okay. And what about the money side? Given those admitted sales figures, over 4.4 crores, what damages did the court award?
This is interesting. Despite those large admitted sales figures, the court actually described its own decision on damages as a lenient view. It ordered defendant number 2 to pay Rs 50 lakhs, that's 50 lakh rupees, or 5 million rupees as damages to GSP. They had 6 weeks to pay, otherwise interest at 6% per year would kick in. On top of that, defendant number 2 also had to pay costs, another Rs 2 lakhs, payable to the Delhi High Court Bar Association's welfare fund.
50 lakhs, compared to 4.4 crores in sales. That does seem lenient. So a clear win for GSP, injunction plus damages. But what was the court's reasoning? Why did they side so decisively with the plaintiff, especially on using that speedy judgment rule?
The court's reasoning was very direct, very focused. First, they pointed out the undisputed facts. Defendant number 2 never disputed the actual chemical composition of GSP's patent claim. And crucially, they never disputed that their product, Roxyfin, had an identical composition. That factual match was undeniable.
So the product match was step 1. But was it just that, or did those admissions really drive the decision, especially for the Order 12 Rule 6 application?
The admissions were absolutely central. The court stated very clearly that defendant number 2 had categorically admitted in those affidavits to marketing and selling the infringing product. The judge found these admissions to be plain, clear, unequivocal, and unambiguous. Because they were so clear, the court felt justified in using Order 12 Rule 6. There was no need, in the court's view, to delve into other potential defenses because the core infringing act was admitted. Okay,
so the clear admission of selling an identical product sealed it. How did the court link that specifically to the Patents Act?
They went straight to the wording of Section 48 of the Patents Act. The court emphasized the language is very clear and unambiguous. It gives the patent owner the exclusive right to prevent others from making, using, offering for sale, selling, or importing. End quote. And the key word there, the court noted, is or. The legislative use of or means any single one of those acts, including just selling, is enough to constitute infringement. You don't have to do all of them. They even cited another Delhi High Court case, Merck Sharp and Dome v. Sanjeev Gupta, which confirmed this disjunctive reading, selling alone is infringement.
So the act of selling itself was enough, regardless of who made it. And what about the use of Order 12 Rule 6, the speedy judgment rule? How did the court justify applying that here?
They reiterated the purpose of that rule. Order 12, Rule 6 is an enabling provision designed for speedy justice. It's meant for exactly these kinds of cases where admissions are clear, unequivocal, and unambiguous. They quoted those same precedents GSP relied on, like Udom Singh Duggal, basically saying if a party's own admissions make it impossible for them to succeed, then a judgment should follow. It prevents dragging things out with defenses that are frankly untenable based on admitted facts.
And how did the court handle defendant number two's main defense, that they were just an honest marketer acting under defendant number one's license and that the settlement covered everything?
The court completely rejected that defense. Two main reasons. First, they said it simply goes against the plain language of Section 48 of the Patents Act. The Act doesn't carve out an exception for marketers or distributors in this way. Selling is selling. Second, allowing that defense would undermine the whole point of both the Patents Act and the Insecticides Act. Getting a regulatory license under the Insecticides Act doesn't magically give you immunity from patent law. They're separate things. So basically, any other arguments defendant number 2 tried to raise were seen as irrelevant because the core fact selling an infringing product was admitted, and under Section 48, that's infringement. End of story.
Crystal clear reasoning from the court there. Was there any disagreement on the bench? Any dissenting or concurring opinion mentioned?
No, nothing like that mentioned in the judgment. This was a decision by a single judge, Justice Sara Banerjee. It appears to be a straightforward application of the law to the admitted facts.
Okay, so pulling back for the bigger picture, what's the real legal significance here? What impact could this decision have on businesses, particularly those in distribution or selling roles?
I think this judgment really hammers home a few critical points. Firstly, it strongly reaffirms that strict interpretation of Section 48 of the Patents Act. Just selling an infringing product makes you an infringer, period. Even if you didn't make it, even if you thought you had the right permissions through your supplier, this is huge for distributors, marketers, retailers in India.
Yeah, that really widens the net beyond just the manufacturer.
Absolutely. Secondly, it shows the courts are willing to use Order 12, Rule 6 CPC effectively. When the facts are clear from admissions, they won't hesitate to grant a judgment quickly, cutting through potentially lengthy litigation. It's a tool for efficiency. And thirdly, it makes it undeniably clear. Getting regulatory approval under one law, like the Insecticides Act, is not a defense against breaking another law, like the Patents Act. You need to comply with both.
So it really sends a message down the entire supply chain, doesn't it?
It really does. The message is, everyone involved in bringing a product to market, manufacturer, distributor, seller, can be held directly liable if that product infringes a patent. You can't just point fingers up the chain. I mean, you often see situations where distributors think their agreements protect them, but this case shows IP infringement liability can be direct and personal.
Okay, if you had to boil it all down to one single, most important takeaway for our listeners from this whole judgment, what would it be?
For me, the absolute key takeaway is this. Ignorance isn't bliss, and neither is relying solely on your supplier's license when it comes to patent infringement. If you are involved in selling, offering for sale, importing, or distributing a product, the legal burden is on you to ensure that product doesn't infringe someone else's patent. You can be held directly liable, even if you weren't the manufacturer, and even if you thought you had a legitimate deal in place. Due diligence on IP is essential for everyone in the chain.
What a deep dive. Well, it really makes you think, doesn't it, about all the hidden complexities in what seem like straightforward business deals, especially when intellectual property is involved.
It really does. And it poses a pretty challenging question, I think. In today's incredibly complex, often global supply chains, how vigilant are businesses really being? Are they truly auditing the IP status of the goods they handle beyond just checking the regulatory boxes? This case suggests maybe not enough.
Indeed. A crucial point. Well, we hope this exploration of GSP versus BR Agrotech has given you a much clearer picture of patent law, how it's enforced, and just how powerful admissions can be in court. If you found this insightful, just imagine the other fascinating legal territories we could explore together. Keep learning, keep questioning, and please join us next time on The Deep Dive.